My name's Andrew Dongworth. I'm a Senior Associate Solicitor for HRJ Foreman Laws, and we are all service solicitors based in Hitchin, Welwyn Garden City and Letchworth. I work in the company commercial department based in our Welwyn Garden City office, and I provide a range of services to businesses, whether that be contract law, company law, commercial contracts or commercial property work. We work to help businesses achieve their goals, to grow and to avoid any potential issues or pitfalls along the way. If you're looking to take a commercial lease or equally if you're looking to buy a commercial freehold, then we would be able to support you through that process. In addition to negotiating the sale contract or the terms of the lease itself, which is obviously a very important part of the process, we advise clients who are taking on commercial properties to allow us to carry out searches in relation to the property. You want to make sure that the property can be used for the purposes that you want to use it for, and if it doesn't have the required planning permissions for that, then that's going to be a problem, and it may be something that may put you off the property entirely, or at the very least would require you to apply to the local authority for a change of use. So we'd also check there weren't any known environmental hazards or any other known issues in or around the property. We raise inquiries of the seller or the landlord, review those replies, and again that's to make sure that there aren't any issues that you're not aware of. If, for example, it may be that property as advertised didn't mention that there was a service charge that was payable each year, or a commitment to contribute to the cost of the repairs of an estate road or an access road, and that's something that our inquiries highlight and be able to be something that we could advise you about. The ability for you to renew your lease will depend on whether your lease has the protection of a piece of legislation called the Landlord and Tenant Act from 1954. Now, the way you're able to renew or whether you're able to renew or not is different depending on whether you have the protection of the Act or not. If you do have the protection of the Act, you will have the ability to ask the landlord for a renewal. So the landlord can't ask you to leave at the end of the term. You can stay in occupation, what's known as holding over under your lease, and you will continue on the same terms until such time as either the landlord or the tenant takes steps to instigate a new lease. That can be done by negotiation, or either landlord or tenant can serve notice on the other saying that they would like to offer a new lease. Now, from a tenant's perspective, you would serve notice setting out the terms that you were willing to pay, and if you can't then agree that with the landlord, there is the ability for the matter to go to the court and for the court to determine what is a fair renewal lease and what the fair terms are. If you're not protected by the Act, so if the landlord at the outset required you to be contracting out of those protections from the Act, unfortunately the landlord is able to ask you to vacate the property at the end of the lease term. If you find that you are in that situation, I would strongly advise that a good few months prior to the end date of the lease, if you want to remain in the property, you start having discussions with your landlord, and hopefully you can agree terms for a new lease that begins immediately upon the end of the existing lease. And if you're not able to agree terms, then obviously you've bought yourself a bit of time to be able to look around for alternative premises. And we can review your lease and we can advise you as to which side of the fence your lease sits on, and therefore how you should be acting and planning accordingly. So if you're selling your business by way of what's known as a business sale or an asset sale, as opposed to a share sale when you sell the shares in the company, the buyer will be taking on the goodwill, fixtures and fittings, asset, and the lease of the premises. Now, in order to deal with the transfer of the lease to the buyer, something which is known as an assignment of the remainder of the lease, again, we need to go back to the contents of the existing lease. In the vast majority of leases, you are allowed to transfer or assign the remainder of your lease to a buyer. However, you do need to get your landlord's consent before you do that. Now, the landlord can attach some conditions to that. First of all, they will want to vet the new tenant to make sure that they're financially sound and that they believe they're going to be able to fulfill their obligations under the lease. So they'll ask for references and the like, and copies of accounts, etc. from your potential buyer. Assuming they clear that hurdle, the landlord will then instruct the solicitor to provide a formal license to assign, and that license gives permission to you as the tenant to transfer the remainder of your lease, but it will also undoubtedly contain conditions such as you would be asked to guarantee the obligations of your incoming buyer. So it is a more complicated process than simply transferring the lease. It's really one of the first things that you need to be doing if you're selling your business by way of an asset sale, is to approach the landlord and get the ball rolling with regards to the lease assignment, because it can take a little bit of time.